Stop talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. Whew, y'all got me working. Y'all got me working. So I think this would be the last of the series until another update comes or somebody asks a question that takes me down another rabbit hole. But I enjoy doing this because I want to ensure, first and foremost, I want to ensure that I have the correct legal information by doing my legal research so that way I can present it to you guys in a way that you guys will understand, okay? So, last video we talked about Carmelo Anthony's case file sitting in the judge's chambers instead of the public record, aka the district clerk's office. A lot of you asked the obvious follow up question. Okay, so what do the attorneys actually do in order to get this file? Because, simply saying it's illegal doesn't get you the file. So today I'm going to walk through the real practical steps based off of my research for forcing access to sealed record or to a sealed record in Texas, using this case as an example. I'm Cassandra, your favorite paralegal, and this is Legal Doc Talk. But before we get into this, I want to ensure I put my disclaimer out. This video explains general Texas procedures for challenging the sealing of court records, illustrated using publicly filed allegations in State versus Carmelo Sincere Anthony. This video is for legal education purposes only and does not constitute legal advice. If you have a specific legal matter, consult with a licensed attorney. All individuals are presumed innocent unless and until proven guilty. So we are going to move on, bring up the little presentation. So I just have a series of documents that I'm just going to kind of present to you guys so you can have more of a visual understanding. So we're going to talk about step one. You have to ask and document the refusal first. So this is the step everyone skips in their head, and it's a very important one. Before you can escalate anything, you have to be able to prove you actually asked for access and were refused. All right, that's not optional. Courts and appellate judges want to see that paper trail. I cannot stress enough that just saying something orally, that does not fly in the court of law. There has to be a paper trail. In this case, that's already happened. There's an exhibit in the motion called the certification of counsel, which I have on the screen, and it documents that counsel, Mr. Russell, or attorney Russell Wilson, asked for the file, and he was told he could see it only if he agreed in advance not to disclose anything inside it. He couldn't ethically agree to that blind, so he didn't. That refusal, now on the record, is what makes every step after this a possible one. If you don't believe me, this was Exhibit 11 in the motion for a new trial and brief in support. His certification talks about how he went to the court conference hearing. He asked for the file. They told him that the file was not available because it was in the judge's chamber and it was sealed by an oral seal, whatever excuse that they made up. So, this is the actual certification that was filed. So, that does take care of step number one. Step number two would be to file a motion to unseal. That is a formal written motion, not just raising it verbally in a hearing. An actual filed motion to unseal or motion for access to court records. That's what you have to ensure is on the docket. So I'm going to monitor the docket closely to see if it's filed either in the trial court or if it's going to be filed in the appellate court. But here's why the written motion matters so much. Right now, there's no written sealing order in this case at all. It's just an oral statement at a conference. A written motion to unseal forces the judge into one of two positions: either unseal the file and send it back to the district clerk, or actually hold the public hearing and issue the specific written findings the law requires before sealing is valid in the first place. Either way, you've converted a vague oral situation into something concrete, a written record that a higher court can actually review later if it needs to. Now, step three, go around the judge to the district clerk. So that is a step that a lot of people don't think of. Just going straight to the district clerk's office and don't even bother with the judge. Why? Well, because under Texas law, as I stated in the last video, the jerk, the district clerk, not the judge, but the district clerk is the official custodian of the court records. That is a statutory role. It is written in the Texas Constitution and statutes. So attorneys can make a direct written request to the clerk for the file or the docket sheet. If the clerk confirms that the file isn't in their possession, that is somewhere else, like the judge's chambers, useful. Now you've got a third party, an official one, confirming that the big one on the screen. All right. If the judge still won't act after a written motion, this is where it gets serious. The remedy is a petition for a writ of mandamus, which is filed with the Court of Appeals, in this case, the Fifth Court of Appeals in Dallas. So, a mandamus is a special kind of appeal. It's not asking an appellate court to review whether the judge got something wrong on the merits. It's asking the appellate court to order the judge to do something they already legally required to do when they simply aren't doing it. And here's why that framing matters. Keeping records in a clerk's custody and following the notice hearing finding process before sealing anything are considered largely ministerial duties, not closed judgment calls. A mandamus, hopefully I'm saying that right, works best exactly in situations like this. You also generally need to show there's an adequate remedy through a normal appeal. And there's a strong argument for that here. If the harm isn't we couldn't prepare our new trial motion in time because we didn't have the file, waiting for a regular appeal doesn't fix that. The deadline will already have passed by the time a normal appeal could even happen. So there also a more efficient path sitting right there already. The motion for a new trial is already asking for an evidentiary hearing on the court room closure. Counsel can ask that the same hearing cover the file custody too, put the judge in a position of justifying the seal on the record under oath in front of everyone rather than a separate proceeding. And that is going to be tricky because the whole thing is they're not trying to have Judge Roach rule on anything. This is a lot. um, the last option, and it's the slowest, unfortunately, a complaint to the State Commission on Judicial Conduct. And it's this form right here, and I provided the website at the bottom. for individuals who want to go ahead and take a look at the complaint themselves. So if you type in that address in your search bar, it will take you to exactly where you need to go, and it will pull up, it will ask you, or not ask you, it will give you a little brief description, and then it'll have two PDF options, and you can click on that first one, which is the complaint, and you can complete it yourself. So I'm just throwing that out there for everybody. But if you go this route, this is the slowest. This won't get the file back quickly. It's not really about this specific document, it's the accountability mechanism if it turns out to be a pattern rather than a one time issue. Okay, so if you're wondering which of these actually moves the needle faster, it's the written motion first and the mandamus. If that gets ignored, that's the real 1-2 combination here. The clerk request is useful supporting evidence. The judicial complaint or conduct complaint is a long term accountability tool, not a quick fix. And like I stated before, Judge Roach is about to retire in December. I'm not sure how effective, he probably won't care if he gets 1,000 judicial complaints filed against him. He's like, I'm on my way out the door anyway. But I mean, at the end of the day, I think people can say that they've done their due diligence, because us, as the members of the public who are entitled to these open proceedings and open files, I think it would do us, I don't want to say justice, but we could do our due diligence on the outside to just ensure that, okay, we're not going to let you off the hook that easy. And hopefully other judges can say, okay, I don't want to be like that judge that just went out the door with all of these judicial complaints, against him. But I'll be watching to see which of these routes the defense actually takes next. Whether we get a written motion to unseal or this jumps straight into a mandamus. But you have to make sure that you are subscribed to my channel so that way if there is an update, you get alerted. But if not, click that alert or subscribe, click the alert so you can follow me. Drop a comment if you want to go deeper into this mandamus petition and how it actually works from start to finish, because I feel that it is a useful thing to understand just beyond this particular case. But anyways, I'm Cassandra, aka your favorite paralegal, and this has been Legal Doc Talk. Bye.